Welcome to the Made in Migration podcast, brought to you by Lawgration, the specialist law firm that helps navigate the complex world of Australian immigration and citizenship law. Here we'll talk about all things to do with migrating to Australia. We're going to learn, grow and be inspired together. Make sure you subscribe and let us be partners on your journey. You're listening to a Lawgration production. This podcast is intended for education and or entertainment purposes only. All content is current at the time of recording and subject to change without prior notice. While Lawgration is an incorporated legal practice, we are not aware of your personal circumstances, needs or goals, and information contained in this podcast should not be construed as legal, immigration or other advice. Before acting on any information in this podcast, you should always query whether it is relevant to your circumstances and consult an Australian immigration lawyer or registered migration agent. Professor Kim Rubenstein is one of Australia's most eminent legal scholars and a champion of equal opportunity and active citizenship. She relevantly wrote the seminal text on Australian Citizenship Law, acting as a consultant to government, including being appointed a member of the independent committee that reviewed the Australian citizenship test in 2008, and appearing as legal counsel in citizenship matters before the Administrative Review Tribunal, Federal Court of Australia, and the High Court of Australia. She is currently a professor in the Faculty of Business, Government and Law at the University of Canberra and an honorary professor at the Australian National University. At the 2022 Australian federal election, she was an independent candidate in the Australian Capital Territory for the Australian Senate. A very warm welcome, Kim.
Thank you so much, Sida. I've been so looking forward to doing this with you.
Likewise. I'm very excited about this episode. There's a lot to cover. I'm wondering if we can perhaps start with the historic evolution of this legal concept of Australian citizenship.
For many Australians, they don't even realise that the actual legal status of Australian citizenship didn't begin until the 26th of January 1949. But it doesn't mean that we weren't thinking about concepts of citizenship as a nation before then. And I think that's a really interesting point, that really from the time of the colonial sort of settlements in the various colonies, Victoria, New South Wales and so forth, each of the people who were born in what was then British territory were British subjects by birth in territory. And that was a common law notion that extended to any person born in territory. So again, just as a sort of an Australian perspective, Indigenous Australians, who of course preceded by thousands upon thousands of years the colonial experience, they were deemed British subjects from the moment that the British asserted sovereignty over the territory, because they were born in territory. And all Australians, all people born in Australia were born as British subjects, and in many ways part of a supranational membership, because British subjects existed in other Commonwealth Dominion countries. And that was something that the British colonial settlers felt very strongly about, so much so that when Canada was the country that was moving to encourage a parallel or a concurrent citizenship of the nation state sitting alongside British subject status, and it was the Canadians who encouraged this to happen around the Commonwealth, Australia was actually reluctant. And that reluctance was born out of both that sort of British colonial identity, but also I think about the evolution of membership as a legal and constitutional concept, because when they were framing the Australian Constitution, they did engage with discussions about citizenship. Would there be a head of Commonwealth power over citizenship? But the feeling was that it would lead them, and I quote here, to innumerable difficulties. And those innumerable difficulties were around the White Australia policy, which was a key motivation for federation, to have a uniform Immigration Restriction Act rather than each of the colonies having their own permutations and combinations of that. And if they were going to have a White Australia policy, what would they do with British subjects who were from Hong Kong and those who were from India? So in that sense, the idea right from the start of membership and citizenship was there, but it was very much influenced by the White Australia policy. And that was the other part of the reason why it took so long for Australian citizenship as a legal term to come into being. But it did on the 26th of January 1949 under the frame of the introduction of what was then the Nationality and Citizenship Act of 1948. And since that time, there has been a legal status of Australian citizen, but there was also a British subject status until 1987. So we didn't get rid of that British subject status. And in fact, the irony is we were British subjects longer than the British. They became British citizens and relinquished the term British subject, but Australians remained British subjects beyond them.
Kim, that's really interesting. We have this parallel development of a distinct Australian identity happening whilst the legal concept is developing, essentially. And
Yes.
that 1948 period, I mean, we have the Second World War, etc. Can you just touch upon that as well with the social conditions? I'm wondering how that influenced the development of the legal concept of Australian citizenship.
Yes, well, at that time it was still very much within that sort of British conception in the 1940s. And in many ways, it wasn't the Australian notion of identity that was driving it. So citizenship sort of was added in, but it was really British subject status that remained paramount. And I would say until the 1970s with the end of the White Australia policy, because the White Australia policy kept that sort of narrow conception of membership. So that we introduced the term, but because British subjects continued to enjoy the same rights and responsibilities as Australian citizens, indeed there are still some British subjects who are on the Commonwealth electoral roll who are not Australian citizens by virtue of being on the electoral roll before 1987, before the term was repealed. So I would say, Sita, that the actual changes occurred more in the 70s with the changes to the White Australia policy and national identity becoming more contested with a multicultural layer to it. But before then, it was still pretty constrained even when we introduced the term. I do argue, though, that the introduction of the term had a sort of a more public law aspect, so not so much about national identity, but about the role of law as a protector of rights. And that is that the term citizen is quite distinct and different to the term subject. I mean, when you think about being a subject of someone, there is a power dynamic that is not equal. You've got the crown and the king or queen who, bestows, it's a benevolent offer of protection over the subject, and the subject is subjected to that power and benefits if the crown chooses to extend that. Whereas for me, the term citizen comes from a more democratic conception whereby those who exercise power are equal to, in a rule of law sense, to the citizen, and we as citizens are equal to those, and in fact they're subject to the will of the people in that they're representing the people. Now, that's another big discussion about the exercise of public power, but I do argue that the introduction of the concept of citizenship was part of that changing evolution of the rule of law and an executive power to a more equal, or that it should be, and to really resist or push back against exercises of executive overreach as going against fundamental concepts of an equality of citizenship.
I'm wondering how the concept of active citizenship essentially plays in with what you're explaining.
So in my thinking about citizenship in Australia, there's that sort of formal legal framework that we've just discussed in terms of British subject status and Australian citizen status. But the actual term or status or representation of the legal form of membership is really just a holder of or representation. It doesn't actually hold in and of itself all the rights that one would normally think of as citizenship. So, for instance, you would think that voting rights were a fundamental part of being a citizen, but there's nothing in the Citizenship Act that says that, nor is there anything really explicit in the Australian Constitution, although the High Court has evolved notions of representative democracy that lead there. But it's actually the Electoral Act that bestows that. And so that's a form of active citizenship that has a legal hook to it, but it's not inherent in the Citizenship Act. It comes from the Electoral Act.
Does that weaken the safeguards against that, in your view?
Yes, I think it really does, because a perfect example of the fragility of that right is that Indigenous Australians who were British subjects, as I mentioned earlier, right from the start, and then became Australian citizens on the 26th of January 1949, as did everybody else, they were not entitled to voting rights under the Electoral Act until 1962, when the Electoral Act was amended. So being a citizen didn't necessarily guarantee a person the rights that we normally think of as citizenship. So to me, that is a real vulnerability, that the gap between the status and the Parliament's decision as to who gets access to those rights doesn't have any constitutional frame. And that was partly because of what I mentioned earlier, that citizenship was not really addressed in the Australian Constitution, really because of the White Australia policy and the fear that it would have unintended consequences or would force the government of the day to allow in British subjects who are not white at that time. So, it is a fragile legal framework within which citizenship operates. So with that in mind, in terms of your question about active citizenship, there is a legal and academic scholar in the US called Linda Bosniak, whose work really has been quite significant for me in my thinking of citizenship. And she wrote a piece called Citizenship Denationalised, trying to think about how we conceive of citizenship outside of the nation state. And she said, well, in order to do this, we have to actually define citizenship. And she said, well, there's clearly the legal status, which we've just discussed, but then there are other ways that we think about citizenship, like political activity, which may be bestowed by legal status, but may be not. It might be that you are an active political contributor without having the formal legal status if you're a permanent resident, for instance. So there's political citizenship or active citizenship. There's citizenship in terms of the concepts of social and economic rights, the idea that as a citizen you're entitled to what the state dishes out and sees as a full member. And then there is citizenship as identity, the way we conceive of ourselves, whether it be through the nation state or otherwise. And so active citizenship to me is more about that political participation, but also in order to be political, you have to have access to the socioeconomic rights and have a form of identity that affirms that. So they're all integrated, but they're all key to me in thinking through citizenship in that more normative sense rather than the formal legal sense.
In the context of a multicultural Australia, multi-faith, multi-ethnic society that we live in, I feel as though this notion of active citizenship is increasingly relevant, at least to further look into. The counter to this might be that the nation state is far from past its use-by date. We still need a national glue, if you like.
Yes.
If that's not a sense of, one sort of ethnic or identity background, it's around this idea of common values.
Yes.
And as you know, the Australian Values Statement, for example, plays a relevant role at the visa process. And then we have our pledge, of course, at the citizenship ceremony. So it's all hotly contested, but a very interesting perspective that you do bring.
Yeah, thank you. I think this Australian values issue is one that we should always, critique or analyse, because if it's one that is respecting of diversity within a common sort of liberal democratic frame, I think that there are obviously clear elements of that are essential for social cohesion. But if it is about something beyond the liberal democratic values that Australians are committed to, then there is a danger of it being seen as a sort of the power play between those in the majority and those in the minority. And I think that a lot of the things that are identified as Australian values are actually liberal democratic values that we believe are important in Australia rather than Australian values, and that multiculturalism is an Australian value, which means that we should be affirming of the multiplicities of, lived experience of what now is over 50% of the country being people who are either born outside of Australia or their parents were born outside of Australia, now making up over 50% of the country. That's significant statistically.
So just on that, Kim, the Section 44 of the Constitution, which was very topical at one stage, I do want to sort of briefly touch on. Let's touch on it very briefly.
Sure.
Do you see a continuing role for that particular provision in modern day Australia?
So I think it's a provision like others that shows that the Constitution is not structured in a way that represents the nature of society today. It reflects the 1890s Australia where it was drafted, and drafted, as we should point out, by largely white bearded men who were very motivated by democratic aspirations, but certainly didn't practice democracy in the way that we would see it today. And in that period, the concept of holding another citizenship was seen as treacherous. It was a very exclusive notion of membership of the nation state, although, there is an irony there because we were British subjects, not Australian citizens. So we had a concept of a supranational membership by having other Commonwealth countries. So it was more about who you were connected, which countries that you were an allegiant to, rather than not only having one. But anyway, over time, of course, that's changed, as we've just discussed. And I think we have moved as a society. We clearly have moved in terms of the Citizenship Act. So from 1948, when that act was introduced, until 2002, there was a provision, which was the Section 17 of the former Act, which said that if you're an Australian citizen and you effectively took up a new citizenship, another citizenship, then you would automatically lose your Australian citizenship. Now, how that's been interpreted is another whole discussion of itself. But in essence, there was an acceptance of dual citizenship from that time forward. Right. Yet the Constitution still has this provision which says that if you are a person who owes allegiance to a foreign power or is a citizen of another country, you cannot even nominate to run for Parliament. Now, it's not even about being voted in, it's that you're not allowed to fulfill that aspect of your citizenship, which is putting your hand up to run and see if the others in your constituency want you as their representative. So it's got a very anti-democratic edge to it, both in that sense, as I've just described, of preventing you from even putting up your hand. But I think in modern Australia, I think we've moved from this exclusive notion of citizenship by allowing dual citizenship to an acceptance of a commitment of beyond one nation state that doesn't necessarily undermine your commitment to Australia. And I liken it to parenting. All of the parents in the world who have more than one child would not see it as an affront that when they moved from having one child to their second, that they were in any way diminishing their love or connection to their first child. There might be times when there are direct conflicts and you have to make a decision in terms of some sort of contest between them. But on the whole, our sense of parenting recognises multiple connections without that undermining our love or attention to either of those children. I think in a similar way, dual citizenship should be seen as something where you can have more than one without that undermining the love or attention or allegiance to any of them, except if there is a direct conflict. And it's only when that conflict arises, and if you're in Parliament and you're experiencing that conflict, that I think you would then have to relinquish your non-Australian citizenship. And but that's far from where we are at the moment.
That's an interesting point you make with essentially conflict management rules that might be deployed in those circumstances. And I guess there's concerns around whether they would be adequate. But that is certainly, I think, a discussion that we probably haven't seen the last chapter in that discussion yet.
I hope not. I think we have a damaged democracy until that point, because if you look at our parliamentary seating, we have certainly seen, by virtue of some positive steps in politics, to have more diversity, certainly within the Labor Party expressing that we see a much more diverse government at the moment than we've ever seen before. But we want that to be the norm, not the exception. And one of the barriers to that is Section 44 of the Constitution, because you're effectively preventing people who are dual citizens from taking that step. And you have to effectively relinquish those other citizenships regardless of whether you're going to win or not. So that's a big ask, I think, And then the last point I would make in this regard is that even if you do formally give up that other citizenship, is that really going to lessen your sense of emotional connection or attachment to the other country? So isn't it better that it's more transparent, so that if you're elected and it's very clear that you are a citizen of another country, if any issues come up, your constituents can ask you and engage with you on that issue and determine whether your decision-making in their view has been influenced by that, rather than just forcing everyone into this formalistic process, which may not change anything anyway.
Now, this is purely for my curiosity, Kim.
Certainly.
You'd probably recall the national discourse around that 2002 period with the Howard government removing the former Section 17. I'm wondering why that wasn't sort of retrospectively applied. What was the logic there?
I think that these things have evolved more than anything else. There is a provision for someone who has lost their citizenship under Section 17 to reapply as a former citizen. But a lot of people don't know about, because it was deemed to automatically occur, if a government determines that that's happened, and I think that often when they do, it's contestable. But if they do, then the period between which you're deemed to have lost it and you reclaim causes a lot of difficulty for a lot of people. And I don't think that was, even though the provision was inserted to enable people to reclaim it, that's one aspect. The other, which is really significant, is for children of those individuals who were born at a time when the person didn't realise that they'd lost their citizenship. And then if they've got citizenship by descent, then that citizenship becomes contested. And we're even at the stage of people who've lived their life as children of those individuals who have also had children who's passed on their citizenship by descent. And that also is causing problems. So I think it's something that's definitely needing more attention now. And I also think as a matter of policy, it would be open for a minister to provide a guideline to decision makers to err on the side of inclusion, so that anyone who has an ancestry connected to another country who in that period took up that other citizenship, there could be a policy guideline to say that the presumption is that the person took up that other citizenship with the belief that they had that citizenship. It wasn't a new citizenship. It was essentially a reflection of an existing dual citizenship. And in that situation, you don't lose your citizenship under Section 17, and that's a valid and lawful interpretation that is more inclusive. But at the moment, it doesn't appear that that's the interpretation the current government is providing.
There's been, as you know, a raft of fairly recent cases handed down by the High Court of Australia about indefinite detention. Obviously, very contentious practice. And for those who are not familiar with it, it refers to the practice of detaining individuals without a set release date. And of course, we're talking about it solely within the context of immigration here, as opposed to criminal indefinite detention or indefinite detention on, say, mental health grounds. Before we delve into the details of indefinite detention, it might be useful, I think, to briefly mention this idea of mandatory detention first.
Yes, indeed.
Mandatory detention for unlawful non-citizens was first introduced by the Keating government in 1992. Shortly thereafter, it was challenged in the High Court on Chapter 3 grounds in the case of what's sort of known as shorthand as the Lim case, so Chu Kang Lim and Minister for Immigration, Local Government and Ethnic Affairs. The court ultimately upheld the mandatory detention scheme there. However, in doing so, it established that the detention of a person would only be valid if it was authorised by law and reasonably capable of being seen as necessary for a legitimate non-punitive purpose. That's become known as the Lim principle. So from there, we then, going back to, I guess, indefinite detention, we see the Al-Kateb case in 2004, where the High Court of Australia upheld the legality of indefinite detention, and 4-3 majority, it ruled that the Migration Act permits indefinite detention of unlawful non-citizens, even if there was no real prospect of their removal from Australia in the foreseeable future. Now, of course, NZYQ came along at the end of last year, and here we're again embroiled in significant controversy. to you, Kim. If you can
Yes.
just talk us through indefinite detention,
I will,
NZYQ.
I think citizenship is key here to remind those listening that the whole framework of the Migration Act has evolved to be about non-citizens and the regulation of non-citizens. And there is, again, a link to our constitutional evolution here, because up until the period in which it was framed in that way, it was more about migration and about immigrants. But the High Court, in a range of cases, determined that migrants could become absorbed into the community and thereby no longer be subject to the power of the Commonwealth under the immigration power, head of power. So there are different heads of power in our constitution federally that the Commonwealth can make laws under. And essentially, the High Court had said, once someone is absorbed into the community, they can no longer be regulated under the Migration Act and therefore could not be removed under the Migration Act. So to deal with that, the federal governments over periods of time changed the Act to be about non-citizens. Now, you'll remember me saying, but there's no reference to citizenship in the Australian Constitution. And essentially what that means is when they're talking about non-citizens, they're talking constitutionally about aliens, because there is an aliens head of power, aliens and naturalisation head of power, which we could spend a whole hour on and sit out talking about that, how that evolved. But that's really important because it reminds us that the framework for the regulation of travel in and out of Australia and the right to be here is around whether you are a non-alien or whether you're an alien. And there's again, an interesting link back to Indigenous Australians, because the High Court, in a very important case of Love and Toms, determined that Indigenous Australians who are non-citizens, because they might have been born outside of Australia and might have a parent, one of their parents is a non-Indigenous person from another country, so they might hold another citizenship and might have been born outside of Australia and never applied for citizenship by descent, they are still able to have a right to live in Australia as non-citizen, non-aliens, because the High Court held that Indigenous people cannot fall under that head of power of aliens. So I'm probably getting a bit too complicated here, but there is actually an intellectual coherence to what I'm saying, because in essence, the only people who can be kept in detention are non-citizens or aliens under the Constitution. So Indigenous people couldn't be kept in indefinite detention, who are non-aliens, but a non-citizen under the aliens power can be kept in detention. But the key point that you've introduced this by is that the High Court held, but only if it is associated with a lawful purpose under the aliens head of power, or if under the criminal law they've been found guilty under the criminal law, like any individual, whether they're an alien or not. The executive has the capacity to bring a case before a court to place someone in detention, a criminal detention. But this is not criminal detention. This is administrative detention. And the High Court has been very clear that there is a power to place non-citizens in detention, but only if it's for a lawful purpose associated with the head of power. Now, that lawful purpose is either to determine whether you're entitled to a visa to stay here, or if it's to determine and process your removal from Australia. And so what was really significant is that in the original attention to this beyond limb with the Alcatab decision, the High Court in Alcatab, mindful of it only being a majority of 4-3, determined as long as the intention is that administrative purpose, that is a lawful detention. Whereas what we saw with the overruling in NZYQ is that, in fact, if it is very clear that there is no prospect of a person being, for the purpose being either that they're going to get a visa or that they're able to be removed, if neither of those two aspects are practicable, then a person is no longer within the power of the executive to be kept in detention and must be released. And so it really is about the capacity of the executive to remove that person in these circumstances. And that's where we've seen a lot of attention in the media. And unfortunately, a blurring, I think, between criminal detention and administrative detention, and too much of a focus by the media, in my view, that aspect of the criminality of individuals rather than the form of detention, because they're not being criminally detained, they're being administratively detained. Now, if there is a framework within our criminal law system for those people to be detained, then that's like any other human being in Australia, that they should be detained for, if it's consistent with our criminal law system, but not to have a special administrative detention for those individuals, because in essence that should make all Australians feel fearful that the executive has the capacity to put anyone in detention for administrative purposes if the High Court had found differently.
And the High Court did clarify that there is a constitutional sort of limit on indefinite detention very recently in the ASF 17 case. So perhaps, Kim, if you could just
a little
tell us
more on that. Yeah. So in that case, the scenarios were, I guess, extended further in that there were two different individuals, ASF 17 and another individual who was whose case was attached to it. One whose case involved mental health issues where the person wasn't able to work with the government to be able to allow them to be removed. And in that scenario, the framework, I think, still would support that person not being in indefinite detention by virtue of an incapacity for them to be removed. The other involved an individual who had not been successful in their refugee application, but who personally felt that they would be discriminated against if they were returned to their country of origin, which is Iran, and so had resisted removal. And my understanding is Iran also will not accept the removal of someone who hasn't agreed to their removal. And so the issue became, well, what is the responsibility of the state in that scenario? Can they be kept in indefinite detention? And the High Court held yes, because there still is a form of freedom by that individual to choose to be removed. The decision still lies with the individual rather than the state. And so that takes it out of the realm of the impracticability of the person being removed. I mean, there's a more nuanced aspect to the difference in opinion between Justice Edelman and the majority, but ultimately those scenarios where people can be removed, but the individual has mental capacity to be able to do something themselves, well, then they can't rely on the decision in NZYQ.
How did you find the timing of the High Court's decision, particularly given the Migration Amendment Removal Other Measures Bill that's currently, as you know, before Parliament, and there's been a lot said about that?
Yes, the politics of all of this, which no doubt we'll return to, is I guess concerning in the sense of creating divisions in society and binaries of approach to who is in and who is out, coming back to the essential notion of who is a citizen or a member and a non-citizen and the active nature of citizenship. But what the government had done in relation to this idea about what is the lawful framework within which someone can be detained? Well, as I said earlier, every human being can be detained if they've been found guilty of a criminal offence, and criminal offences are determined by courts. And if the court determines that you have conducted a criminal offence, then it is within a liberal democratic society, within the power of the state to ensure that you are detained or you're placed in jail, as we know, we think of our criminal law system. And so what the government has done has made it a criminal offence for individuals resisting their deportation. So it becomes a very interesting play with words, arguably, has it become an Alice in Wonderland scenario where you make certain things criminal offences that a judge would then have to find a person guilty of and place. Now, what if the criminal offence was that you had brown eyes and that became a crime? I mean, I am harking back really to fascist or Nazi regimes where individuals were identified as effectively being criminals of the state and being able to be treated differently. So I think even though that is a very overblown representation of the power of the state, in this circumstance, it is something that we need to be mindful about, and it would be very interesting if that legislation, which is still, I understand, before Parliament, if it were to ever be implemented, and I think it's probably questionable given the nature of the Senate, but who knows in terms of political possibilities. I think there'd be some really serious questions for a court to determine the lawfulness and capacity of the Parliament to determine certain things as criminal matters within our rule of law system. So that may be ahead of us, Siddhar, but they're certainly the issues that people need to be thinking about morally and legally.
I think it's probably fair to say that further litigation appears to be inevitable in this space.
It does. And people who are perhaps critical of migration lawyers and scoff and say this is exactly what lawyers want. Well, in a liberal democracy, if you want to protect rights, you need lawyers to be able to do that. And so I think we all benefit from those lawyers who do take on these cases that are very significant in terms of the human rights and liberal democratic principles that most people take for granted, but are certainly not guaranteed necessarily always to everyone.
Now, Kim, on a completely separate topic.
Yes.
It'd be remiss of me not to ask, of course, whether you're thinking of having another tilt at parliamentary politics in the foreseeable future. Can you give us a bit of a spoiler?
Yeah, well, I guess the context for those who don't know about my 2022 experience, and as you introduced me at the beginning, Siddhar, I decided that I would I've always been an academic that believes in my role and responsibility as a sort of an expert to contribute to public policy. And so that has largely been within citizenship legal frames. I've kept my practicing certificate and often acted pro bono in sort of cutting-edge citizenship cases, as you know. I also was a consultant to the department in the rewrite of the 1948 Act that we mentioned before, when it was repealed and reenacted as a 2007 Act, and I was a consultant to the department in its drafting of that legislation and ultimately Parliament passing that legislation. And then I also, in 2008, was an independent member of the review of the Australian Citizenship Test, which had been introduced after the 2007 Act had been introduced. And so I've always been, I guess, an active citizen in that practical aspect of my academic interests. But I decided in the lead up to the 2022 election that there were lots of policy issues that I felt I had a lot to contribute to the national parliament, and it would be a good experience to experience what it's like to be the candidate rather than the person lobbying the candidate, lobbying in an expertise sense, and consistent with the fact that I've always been an independent commentator, critiqued both sides of government, that I would run as an independent. And for the Senate here in the ACT, and as we know, in order to run to vote for the Senate, the ballot paper has both above the line and below the line voting, and about 90% of Australians vote above the line, and in order to be above the line, you need to be an Australian political party. So I effectively formed the Kim for Canberra party, which required 1,500 members, and nominated to run as an independent for the 2022 election. Even though I was not successful, a very solid independent candidate, David Pocock, of course, as many know, was elected. And so my participation, I think, without putting too bigger weight on it, was significant in altering what had been up to then always a Labor and a Liberal representative, but more importantly, made it a real contest. There was real attention in the ACT as to the nature of representation, which was healthy for democracy. One of the aspects that I put into the public policy debate at the time, which was entirely relevant for the ACT, was the number of senators that we have. So as a constitutional scholar, I know that all of the original states are guaranteed equal membership, which began as 6 at the time of federation, but has grown to 12. But the ACT and the Northern Territory have only ever had 2 senators, and that was introduced in 1975, found constitutionally valid by the High Court in the Territory Senators' cases, and not constitutionally linked in the way that the states are to the numbers in the House. So you could theoretically have 12 senators for the ACT and the Northern Territory to make them equal, but I don't think that that's likely on the political horizon to introduce that many for the territories. But I did argue that the numbers of people in the ACT had doubled since 1975, and also for the period from 1975 until now, the states had grown by 2. In 1983, that increased from 10 to 12, so that it was only fair that the ACT should increase from 2 to 4, and I had no problem with the Northern Territory doing the same. So that was a very key part of my campaign, and one that David Pocock said he would be happy to continue pushing for at the next election, in advance of the next election. And positively, the Labor Party have said themselves that they have adopted that as part of their party platform. What is not clear is whether they'll amend the Electoral Act. And it's just a simple amendment to the Electoral Act to increase the number of the territory senators from 2 to 4. It wouldn't require much legislative drafting at all. In fact, I drafted the bill as part of my campaign. So there's something
You've done all the hard work.
Yes, indeed. So if that happened before the next, that's a very long-winded way of talking about active citizenship, which is important to me. But also in terms of answering your question, much will depend on whether there are if there are 4 senators to be elected at the next election, I would seriously consider running again. But again, there were so many different factors that made it right the last time around. I'd have to reconsider, but that would be one of the factors that I would have to take into account if there is not an increase in senators. And maybe this will be something that will have an influence on whether they do this before the next election. I doubt very much that I would put my hand up again, because I think that the contest would be clearer this time than it was when I put my hand up last time.
I think we should be watching this space. It's been an absolutely wonderful episode to have Professor Kim Rubenstein on the podcast. Thank you so much for your time.
Well, thank you so much for initiating this series, and I hope that people appreciate the time you're putting into this, Sita, because it is a public contribution. I would say it's a form of active citizenship, of education and discussion about really central public policy issues. So my hat off to you as well.
Thank you. You've been listening to a Lawgration production. This podcast is intended for education and/or entertainment purposes only. All content is current at the time of recording and subject to change without prior notice. While Lawgration is an incorporated legal practice, we are not aware of your personal circumstances, needs, or goals, and information contained in this podcast should not be construed as legal, immigration, or other advice. Before acting on any information in this podcast, you should always query whether it is relevant to your circumstances and consult an Australian immigration lawyer or registered migration agent.